Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. This is our part 2 for the 14th Amendment because the 14th Amendment needs definitely more than one episode. If you've not listened to the previous episode, we kind of go into the, looking at the history of it and what it was trying to fix at the time. But Dr. Weinberg is back with us, and today we're kind of talking about incorporation. And I want to start off by James Madison had originally had an incorporation amendment with his, original drafted the Bill of Rights, and it just didn't make it through. So I feel bad for James Madison because he never got to see or know this kind of passage of this little piece. But
I will say he was trying. I generally really like James Madison, and I very much approve of.
I feel a butt coming.
Well, because we talked about this before, but in that first Congress, many folks like, all right, well, let's just get to building the government. He said, no, we promised them a Bill of Rights. We got to do this. We are honor bound to do this. Let's collect all their materials. And so I appreciate very much that Madison was trying to faithfully represent the ratifying conventions. And I also am very much on board with the idea of a core set of rights being universally applied throughout the Union, but he was trying to steal a base there and basically smuggling through something that was his own hobby horse when he was trying to say, we have to do this because the people have spoken. So He's right on the merits. He's right on the Bill of Rights. I do think he was trying to kind of sneak in a little bit by wanting to incorporate. Again, it wasn't the whole set. It was mostly like the First Amendment and jury trial. But
so when we talk about incorporation then, right, and the last episode, we kind of talked a little bit about it, but I want to talk more about what is incorporation when we're talking about the 14th Amendment.
Yeah, so in Section 1, and I'm not going to be more specific than that originally here, there is seemingly language that people have pointed to later to say that the first 8 amendments of the Bill of Rights are applied to the states. 9 and 10 are both federalism provisions about the difference between federal and state authority. And so historically, for weird reasons we'll talk about, they pointed to the due process clause. I think scholars more recently, and I think more sensibly, have said that no, it's probably privileges and immunities. But if you look at the debates they're having, many of them say, yep, what the purpose of this is to make sure that there is a floor of rights that are guaranteed to folks in the states with an additional federal redundant backstop. Because it's worth noting, most of these rights in the first 8 amendments, in some formulation or another, are in the state's own constitutions. This isn't like suddenly saying, aha, you have to have free speech, this crazy idea that you've never heard of before. Like, no, it's in their state constitutions. Some of the southern ones have, like a comma, except for white people kinds of language in there. So like their arms provisions often will have white, explicit white supremacist language. And again, like all of the exact protocols of like when you have to have a jury trial for dollar amounts. Okay. But the basic core of like, you have to have due process, you have to have jury trials. This is already in the state constitutions. And so the argument is, look, Article 1, Section 10 is a list of guarantees. In the very original Constitution, the states can't screw around with the contract after it exists. And so the argument is, we're not saying every right in the whole world, but what's in the Bill of Rights is a core floor, should be independently enforceable by the feds against the states. And so their argument is this is not a major violation or modification of federalism. It's a guarantee that basically the states already are putting forward saying, and we'll additionally reinforce them. Oversimplifying a little bit, because again, some of the states don't have an arms piece. Some of them don't have exactly a different form. Some of them actually do have speech relatively late in their text. But basically, the original idea of incorporation is the first 8 amendments to the Bill of Rights apply to the states. That the Supreme Court in 1876, everybody blames this case called the Slaughterhouse Cases. You've probably heard people complaining about that. The Slaughterhouse Cases is not the bad guy. It's a case 5 years later, or a few years later, called the U.S. v. Cruikshank, where the Supreme Court says Bill of Rights isn't supposed to apply to the states, only to the federal government. And then he cites a Supreme Court case from 1833, which is a good case to cite, and it was accurate at the time. But a little thing called the 14th Amendment has happened between 1833 and 1876. And so Cruikshank says Bill of Rights doesn't apply to the states. And so incorporation seemingly gets foreclosed for quite a while until it gets brought back by a really ugly, messy process, which we can decide how much we want to torture our listeners in going through that. But so
I mean, the answer for me is let's torture them, because I think that it's an interesting thing, because the 14th Amendment didn't just say, okay, everything applies. It's full incorporation. It comes very selectively through Supreme Court cases. I mean, that really just isn't the first one on freedom of speech.
It depends on if you want to squint and count an eminent domain case from the 1890s. So I generally think that Get Low 25 is the one that you're alluding to but there are some historians that point earlier. So you can't even get to incorporation without a little side quest to this idea of substantive due process and liberty of contract.
Okay.
Which basically in the 1870s, if you read the Cruikshank case, you read the Slaughterhouse cases, the concurrences and dissents, they say, some of them say just the Bill of Rights. A few of them, particularly those folks who are associated with the Lincoln appointee Stephen Field, who is on the court for a long, long time. Field is very much a hardened libertarian, and he has the view that basically the Civil War creates both political and economic liberty, and that effectively part of being freed from slavery is now that you are a part of this robust market economy. And so all citizens have to have very sort of robust, basically free market assumptions. And this is why, again, the Civil Rights Act of 1866 has all these contract provisions. I read it as effectively just saying it has to be sort of neutral across lines, but doesn't say you have to have those necessarily. But Field and others increasingly say that there are fundamental rights, even if they are not enumerated in the Constitution, of contract and property, that no legitimate government can interfere with. And they eventually point to the Due Process Clause, which is, to my mind, an odd place to point to it, because due process literally is about process. It explicitly says, in fact, you may be deprived of life, of liberty, and property with due process. Nonetheless, Field and his crew quickly point to the Due Process Clause. And though they create this doctrine that scholars later call substantive due process, they call it liberty of contract at the time, that there is some level of presumptive free market regulation, free market policies that have to be guaranteed with the fundamentals of American citizenship. And so, again, how widely this gets used, I think, gets exaggerated by Theodore Roosevelt and others later, but they are striking down minimum wage laws, for example. They strike down, in a couple cases, or one case, the Lochner case, maximum hours, although the fact pattern on that one is so weird. They strike down some policies about basically trying to protect unions. And so you have this weird universe between 1880, 1890 and 1925, in which the Supreme Court has said, with John Harlan in the 1880s or in the 1890s, 1900s, is the only one saying, yeah, the Bill of Rights is applied. The Bill of Rights isn't applied to the states, but this economic liberty is. And this seems kind of inverted on textual grounds. And so, as you alluded to, the Supreme Court doesn't say, oops, we made a mistake. We ignored incorporating the Bill of Rights. They instead say, what rights are also fundamental, like free market liberties? And so they start picking out the pieces of the Bill of Rights, and they say, we're not incorporating it because it's in the Bill of Rights. We're incorporating it because it's super fundamental and important. And the courts spell out these sort of criteria for deciding what right in the Bill of Rights is fundamental enough that it applies and what right isn't fundamental enough that it applies. And very famously in the 1940s, Justice Hugo Black says, I don't like this, where the court gets to say what's important and what's not important. Our job is to enforce the law. He is a critic of that liberty of contract doctrine. He says, look, this is making up rights that aren't in the Constitution. We don't have a right to do that. We also don't have a right to ignore rights that are in the Constitution. Let's do this in a nice and clean way. If it's in the Constitution, in the Bill of Rights, we will enforce it. If it's not there or reasonably derived from it, we won't. So he wants to make very much a textualist critique. The Supreme Court says, no, we're not going to do that. And bizarrely, instead, for decades afterward, they will continue to say, we're not incorporating it because it's in the Bill of Rights, but because it's fundamental, such that fundamentally you get to the point where almost all of the rights are incorporated, but with this backwards doctrine. And literally today, 10 years ago or 15 years ago, so the Supreme Court said, is the Second Amendment applied against the states? And the majority of the Supreme Court says it is, because it's super fundamental and important, because it's in a whole bunch of state constitutions and it's in Blackstone and it's in the 1860s debates. And Clarence Thomas wants to basically say, look, Hugo Black was right. It's in there, so we apply it. It's not in there, we don't apply it. But he writes this in his own concurrence saying, we're going to use the privileges and immunities for total incorporation. None of this weird selective stuff. And the majority basically says, look, we've been doing it wrong for 100 years. We'll just keep doing it wrong. And eventually it'll sort of look at, and when they, more recently after that, it was Timbs, I think in 2018, it was about excessive punishment. And again, they don't do this. They do the same, like, we're just doing this through the due process clause, even though it's probably wrong and a stupid way to do it. So that today, functionally, almost all of the Bill of Rights is incorporated. They don't have the $20 jury piece, and there's a couple of other minor pieces, but basically it's almost all been applied. So we are functionally in a Hugo Black, Clarence Thomas world of we enforce it because it's in the text of the Constitution. But theoretically, doctrinally, we are still we're only picking out the important pieces and enforcing those. And then in the 1930s, and backing up, Hugo Black in the 1930s gets the Supreme Court to say, you know what, we're not doing liberty of contract anymore. That's not a fundamental right. We're only going to do stuff that's in the text. We might not do everything in the text, but we're only doing stuff that's in the text, which is partly why Hugo Black gets so furious in the 1960s when the Supreme Court uses substantive due process reasoning again to say, there is a right to privacy, and then from there, a right to abortion. That Black is furious because he thinks that that's doing the same thing they were doing in the 1930s. Instead of, he wants to have a sort of textual in or out kind of framework. The Supreme Court obviously has foreclosed the abortion case in the framework in Dobbs. They have not officially gone back through and said, we're never doing an unenumerated fundamental right again. But the framework in there basically says, you have to show us it's really, really deeply rooted in history, which is my sort of cynical take, is them saying, we're not going to go close other stuff off, but stop sending us these cases. So I think functionally, substantive due process is basically closed, and functionally incorporation has been reached, but there's still some wiggle room because courts don't like screwing with doctrine more than they have to.
I'm glad that you brought up the Timbs case, and it's TIMBS yes. Versus Indiana. I will say, if you are a teacher listening to this, my students loved that case because really it's talking about a Land Rover and whether or not like that's excessive. It's a very interesting case, and I think that kids really like it. You know, we talk about incorporation, like the Third Amendment's not incorporated, right? We haven't had
a
quartering of troops.
You have to have a test case to get it incorporated.
And then grand jury indictment, I don't believe has been incorporated.
I think grand jury had. No, you're right. No, you're right. You can still.
And that's a part
by information. That's right.
Yeah, that's a part of the Fifth Amendment, right? Other pieces have, and then I don't know that the Seventh Amendment has, like a civil jury trial. So it's an interesting,
that's right,
like thought experiment, you know, to go through and to look at these. And Dr. Beinberg, you brought up a couple of Second Amendment cases. We do have podcast episodes on those to kind of help you out, but it's an interesting thing to just go back and look at, you know, the constitutional discussion of, you know, just selectively incorporating or just saying everything is incorporated. And when we talk about, again, incorporation, we're talking about the First through the Eighth Amendments, because we've done, podcast episodes and talked plenty about the Ninth and 10th Amendment.
But
Do
it
you want
also
to go
has the
back?
side piece. But it also has the side piece of total plus, or are you doing other unenumerated rights, or are you not doing those rights? Because there's a piece that sort of dovetails with incorporation, but it either expands or contracts it depending on who you're looking at on that too.
So can I ask a question then? Because you brought up abortion, and that's unenumerated, right? Because it supposes privacy and whatever else. I'm trying to think of how to phrase this, and I can cut it if we need to. Because medical privacy and abortion is not listed in the first 8 amendments. Like, there is
Right.
not that. So when we talk about unenumerated, rights being incorporated, that's a lot of the debate over abortion is who has the power to make that decision. Is it the federal government? Is it the state government? Is it kind of that back and forth?
Well, I mean, so that's a federalism piece though, because that's a question, because like Roe didn't say the states can't do this, but the feds can, or vice versa, right? It was a civil liberties. It was an individual rights sort of a claim versus a powers claim. And when we talked about the 10th Amendment, I mentioned that the federal effort to regulate abortion with the Commerce Clause, they didn't make a federalism claim. They just tried to basically say there was individual liberties claims on that. And it's worth noting too, like even going back to like the Griswold case on privacy, one of the dissenting justices said, look, there's a better way to do this, which is this is a Fourth Amendment case, because this will never be enforceable against private people in their own home if you just do the Fourth Amendment sort of normally understood, right? You don't need to expand to the sort of broader understanding of privacy, which is just like, it's in your house. This is unenforceable. So it's worth noting that even then, it's not like saying, there's no way in which there's ever going to be a civil liberties protection that's relevant. So, I mean, and obviously, there's always going to be marginal cases of, even if it's a First Amendment case, does some sort of secondary consideration, is a campaign contribution speech or not? Is a campaign expenditure speech or not? Is the football coach praying on the field while he's in play, is that free exercise of the kind that's understood by them, or does it refer there are always going to be cases where you're trying to figure out even what's the contour of the rights. But other than Roe doesn't try to say this is the Fourth Amendment broadly understood. This, like, it tries to say there is an underlying right, and they explicitly say we're not even going to say whether it's from the Ninth Amendment or the 14th. Like, they're agnostic on that, which is they're not even trying to sort of connect it to one of the others, which is one of the things the dissents complain about, which is like, this isn't even in the most expansive understanding of incorporation. Griswold, the privacy case on contraception, the majority opinion does sort of do that. Douglas wants to say there's kind of a First Amendment floating around. There's kind of a Fourth Amendment floating around. There's all these, this is where the phrase penumbras and emanations comes from, because he wants to do like a really, really, really expansive, like it's kind of from the Bill of Rights. But then the concurrences say like, no, we don't need to do this thing. We're just going to call it a fundamental right, like they did in the 1920s. And amazingly, and this is actually what causes Hugo Black to lose his mind, they actually go back and they cite those liberty of contract cases in that, which Douglas had been on the record decrying for years, writing opinions saying these are awful. And so Black is furious that more or less that Douglas is just being such a naked hypocrite of these cases are evil, but like we've overturned them, but now we've unoverturned them for this different thing that I like. But this is why you could go through days on just trying to figure out. Then we figured out sort of what's in selective versus total, but also are we doing fundamental or not? Which is why the courts, I think, have wanted to move away from that for a long time. There is also one other piece that we haven't really talked about, which connects to this, which is the equal protection piece, which is where some others have suggested, for example, you might find a right to abortion, for example. But the equal protection clause is probably the most, if even the incorporation is not nearly as convoluted as equal protection law, because people want to say, well, 14th Amendment says laws have to be equal. Well, what does that mean? Because all laws classify, right? A law classifying an employer and employee is a classification, right? A law classifying a minor versus an adult is a classification. A law classifying, you can spell out whatever it is, right? A veteran versus a non-veteran, a retired, all laws classify. And so the question that the 14th Amendment basically gets to deal with is, what's the difference between reasonable classifications that are an actual like relevant difference and those which are arbitrary and like basically pointless other than some kind of discrimination? And even the framing like that is like, well, that seems like it's endlessly malleable. But that's largely the way that the 14th Amendment doctrine has evolved, is people say, this law that seemingly, we didn't really think that it was arbitrary, and now we think that it is. So, for example, this is where, the early 1870s cases, there are Minor versus Happersett and others, there are women that say, like, the fact that I can't practice law as a woman, that seems arbitrary. The question is like, can I do the bar exam? Or have I, have I read law with somebody? And they say, look, it's not arbitrary because like gender is real and this is different. And so they just sort of brush that aside for a while. And then later on in the 60s, basically as the ERA is running, first in the 20s, they tried in the 20s, and then, in the 60s and 70s, the Supreme Court says, we are not going to say, for example, all laws classifying based on sex are unconstitutional, because they say like there are places that like sex is a real thing that matters, and so therefore it's not all arbitrary. But like whether you can be the executor of your father's estate, like that's completely arbitrary. And so the court, and so students get frustrated by this too, but they have all these, and I will spare your listeners all the convoluted discussions of the tiers of scrutiny and all of intermediate scrutiny and all that. But the basic framework that the court has tried to make is to say laws that classify based on something we think almost never relevant, like race, right? Presumptively unconstitutional. Laws that classify based on things that might be relevant in some cases, but you need to be skeptical. It's not just stereotyping. That's basically sex. And then other laws that classify, again, based on employer versus employee, that's either within the state's police powers or, or the federal government if it has an enumerated power. Issues related to sexuality have sort of shifted up to, so originally, they argued it is rational to distinguish between marriages between a man and a woman and two men, for example, because they would say classifying based on that is rational to what we think marriage is. Later on, the Supreme Court says, well, no, we increasingly don't think marriage is as tightly connected to, say, child rearing, for example. And so therefore, what had not been an arbitrary classification looks more like one. And the Supreme Court uses substantive due process in Obergefell, but the lower courts are using more or less normal equal protection reasoning. But that's basically how it is. And so stuff kind of has sometimes moved in the tiers, so that, for example, even classifications based on sex, officially they use a tier of scrutiny, but functionally, in some cases, it looks closer to a race, skepticism based on race. So, but that's the basic framework that the courts try to use. Is they say, is this classification basically arbitrary and pointlessly discriminatory, or is it recognizing there's some actual sort of good government policy justification for this classification?
Really, those foundational cases are Plessy versus Ferguson, the, separate but equal, and then Brown versus Board of Education, correct? Like looking at that equal protection, because with Brown, out of the Supreme Court, it says it's inherently unequal. Like there is no reason to do this.
That's right. Yeah. So Plessy's a weird case, and we'll talk more about it in a podcast.
Yeah.
The majority opinion, particularly in Plessy, is just weird. But Brown basically says, these weirdly, horrifyingly, do you know the case that comes up with the idea that racial classifications are presumptively unconstitutional?
Oh God, no, I don't.
Korematsu. It's Korematsu.
Oh,
it's Korematsu.
interesting.
Where they have this aside at the beginning where they say laws classifying based on race are presumptively unconstitutional and a very, very, very bad idea. But in this case, we'll allow it, right? And so this is partly why I actually really loathe the strict scrutiny framework, because it basically concedes like, yes, you are breaking a right, but if it's really important, we'll let you do it. And that comes from Korematsu saying, yes, racial classifications are probably bad, almost always bad, but not in this case, which the dissents just ream them for. And they say,
Yes.
Robert Jackson's dissent in Korematsu is one of my favorite opinions, which is basically like, he even says at one point, we shouldn't have taken the case. We should have just let the feds run internment, because as bad as that is, we were never going to stop it during a war. But we've left this loaded gun lying around where you can say, we can classify based on race if it's really important right now. And he says this is going to get, and eventually that doctrine gets tortured out into, you have strict scrutiny on other case laws where the Supreme Court has said we can violate, or where several justices, I should say, on the Supreme Court in the Smith case, in the dissents, say we can, I guess it's the concurrence, we can violate an enumerated religious liberty right if we think it's important, because, and what if we've moved from the Japanese are going to beat us in World War II to if kids use drugs, right? So like once you've created that loaded gun that is effectively we can break the law if it's super important, then that's that. So yeah, Korematsu is the one that originally comes up with the strict scrutiny framework. And then they develop it a little later. But yeah, Brown basically says like it's presumptively unconstitutional. And then there's a few cases afterward where they say, look, classifications based on race are just, Loving v. Virginia has a similar piece where they say, look, this is seemingly a very arbitrary, purposeless classification. And then, the court sort of relaxes that a little bit. They use the strict scrutiny framework in the affirmative action cases like we talked about. And then they close it back off in SFFA case where they say, we're going to use the Brown framework rather than the sort of backy carve out to say, we're going to allow it in this case because it's so important to allow academic diversity, for example. So strict scrutiny is, in theory, as they say, strict in theory, fatal in fact. It seemingly is looking like it's closer to fatal in fact in enforcing that. But yeah, the mid 20th century case law has all sorts of little wild forays like that.
It's just interesting. And for our listeners, Loving versus Virginia is about interracial marriages. I know that you brought up a case, Reed versus Reed, about, who can be the executor of an estate. This is, and listeners, I am trying really hard to keep this short because this is like the case law that I love because it is so complicated. And, if you are not familiar with Korematsu, Fred Korematsu took the United States to court because he was a U.S. citizen interned during World War II, and he lost that case.
Yep.
And this is, when you're talking about this loaded gun, that's what it is. And I don't think it comes up again until Trump versus Hawaii. Yep. And the Supreme Court doesn't overturn Korematsu, but they just say that shouldn't be a thing.
Well, they can't legally overturn it strictly because it's about a different thing. So they call it precedential value into question, which is fair enough. It's not being cited approvingly, but there is a weird period where they're citing laws are presumptively unconstitutional. See Korematsu. You're like, why do you have this in here?
Oh my God.
They eventually quit citing Korematsu and cite the other cases that were citing Korematsu, but
it is. And now I'm like looking at our list for the rest of the time, making sure that we have some of these cases because it is, we talk about the 14th Amendment, we talk about incorporation, substantive due process, equal protection. It is, especially in the 20th century, there's so many cases that look at this, and I think the most famous one is Brown versus Board of Education, but there are so many others. So listeners, stay tuned. There will definitely be more on this. And I think that I am going to convince / kindly bully Professor Weinberg into doing these different levels of scrutiny when we're evaluating laws, because I do know that it shows up on a couple AP tests. So Dr. Weinberg, thank you so much.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.